Hi everyone, my name's Fabian and I'm a corporate lawyer at Travers Smith. Getting the legal basics right are important at the beginning of your journey because doing so can help to preserve and even create value for your business as well as to generate investment, whereas getting them wrong can lead to increased costs, reputational damage and even, at its most extreme, the loss of your business. Now, different businesses will have different levels of legal risk, but the basics are important for every business. But the key thing to focus on at the early stage is taking the legal steps that either create or preserve that value to your business or that help to generate investment. There are lots of legal items to think about at the start of your business, and we'll run through them now in turn. Firstly is registering your business. Now, when you're trading without a limited company, if something goes wrong and a customer sues you, they'll be going after you personally and against all of your own personal assets. Whereas if you trade through a limited company, they will only be able to go after the limited company's assets, which help to protect you. And this concept of limited liability is why most founders choose to trade through a limited business. The registration process is really straightforward. It's easy to do on company's house website, and there's a simple step-by-step guide there. Or if you're struggling, there are registered agents that can assist with that service relatively cheaply. So once you've registered your company, you need to think about corporate housekeeping. Now, you don't want to get too bogged down into the detail at an early stage, but there are some important steps to take. Firstly, your register of members. That's the legal record of who actually owns your business. So if your name isn't on the register of members, you don't own the company. You also need to make filings at Companies House. So there's some filings that need to be made annually, such as the confirmation statement, which confirms who holds the shares publicly, as well as your annual accounts. And there's other ad hoc filings that you'll need to make at Companies House when you make changes, such as when you change the directors or when you issue new shares. The other thing to bear in mind about a limited company is it's treated in law as a separate person, just like you and me. This means that any money that's in the company is owned by the company rather than by you as a founder. Therefore, you need to be very careful before moving any money out of the business, and there's very strict rules that govern that process. Another thing you'll want to think about when you're first setting up your business is a founder's agreement if there's more than one founder, or in due course when you bring an investor on board, a shareholders agreement or an investment agreement. And this governs the relationship either between multiple founders or between a founder and an investor. And there's a number of things to think about in the context of these agreements. Firstly, there's the equity split. So how will the shares be owned? In a founder's agreement, it's typical just to split the equity equally between all founders. In a shareholders agreement, you will often have a separation between shares that relate to money that's been invested by an investor, and there'll be a concept of sweet equity, which is where effectively management and founders are rewarded for the work that they put into growing the business. You'll need to think about decision making. So partly that's going to be who sits on the board of directors, but also what decisions can those directors make? Are there certain actions that need the consent of an investor who's less likely to be involved in the day-to-day running of the business? You need to think about things like return of capital. So what's going to happen in the event of a sale or a winding up? What happens to that money and how is it distributed between the parties? So once you've got your basic corporate setup, the next thing to think about is, how am I going to trade? And one of the key things to think about here is then contracts with suppliers and customers, which is going to be your run-of-the-mill everyday contracting. Now, an important thing to put in place at an early stage is some standard terms and conditions that you'll look to enter into contracts on the basis of as much as possible. And there's plenty of resources available online to be able to put these together. And for most businesses, fairly generic terms and conditions will be all that you need really at an early stage. But if you do anything such as heavy data processing, for example, you'll need to think about if there's any specific things to your business to include here. If you're not able to contract on your own terms and conditions, then you'll find that you have to negotiate with customers or suppliers on their terms. And there's some key things to watch for here. Firstly, there's warranties. Now, these are effectively promises from one party to another about the quality of a service or a good, or about its fitness for purpose. You'll have to think about your respective obligations. So are you going to be able to deliver everything that you say you'll deliver? And are you getting everything you need from the counterparty? Think about indemnities, which are effectively promises to pay for every pound of loss suffered by the counterparty, you'll pay them £1 in return. So they can quickly rack up to a significant cost. So you want to think in particular about liability caps. Often this is matched to a percentage of the fees or a multiple of the fees received, or in line with the insurance that the counterparty or you have available. Other things to think about are the term of the contract. So how long is it going to last? Is it going to be long enough to give you the security that you need in that contract? And is it going to be too long that actually you're stuck into a contract that no longer works for you? And linked to that, think about termination rights. If the other side isn't delivering on what they need, are you going to be able to end that contract, and how? And to be honest, even if there's no particular issues with the contract, if you just find it's no longer relevant, are there any rights there for you to terminate? Confidential information is a really important asset to your business, and it's important that you protect this. The most common way to do this is through a confidentiality agreement or an NDA. Now, you'll tend to come across these in, for example, conversations with potential customers, potential suppliers, or in the context of employees or potential business partners or investors. And there's a few things to watch for in particular on these. Firstly, does the definition of confidential information sufficiently protect what you need it to? So is it wide enough to cover everything you want it to cover? How long does the NDA last for? So if it's only for a very short period of time, then actually someone can go off and use your confidential information in pretty short order, which doesn't really work for you. And also think about whether you should include any non-solicitation provisions or non-contact provisions. So these would stop a counterparty from contacting your customers or your suppliers to try and entice them away, or similarly to try and contact your employees and to employ them. And as we mentioned before, bear in mind any indemnities that might be included and think about the potential consequences of those. As your business grows, you might want to look to take on employees. And there's again a few things to think about here. Firstly, employee classification. So is the person you're taking on a worker or an employee? And the reason the distinction is important is because employees have access to a much broader range of employment rights than others. It's not a decision you can just make, it's a question of law, but there's plenty of guidance available online to help you make the decision about, in practice, whether someone is an employee or a worker. As a fledgling business, cash is king, and so you'll be torn on the one hand between wanting to use your cash to attract the senior employees that you want to help grow the business, but also wanting to preserve that cash to be used elsewhere in the business. And the way that many startups operate is to provide equity to key employees to help bridge the gap between the cash you can pay them and the cash that they would expect to receive. And the other great thing about this is it can really help to motivate them and feel part of your corporate journey. Now, the thing to bear in mind, of course, is that if they leave, you want to ensure that there are clawback provisions, either in their employment contract or elsewhere in your shareholders agreement, so that you can get those shares back again if they leave. Because why should they benefit from everyone else's hard work if they're no longer with the business? The other things to think about in an employment contract are things such as confidentiality, so you make sure that you protect your confidential information from your employees, as well as non-compete provisions. So those would be things that would stop them from just running off to a competitor or starting up their own business. But the thing to bear in mind with that is it can only last for as long as is reasonable, which is very much context dependent. So always think carefully. If you try and make it too long or too wide a restriction, then it may not actually be enforceable. The other thing to think about is termination rights. Everyone hopes that an employment situation goes well, but if not, you need to know how you're able to terminate the agreement and whether you're able to do things like put them on garden leave or give them payment in lieu of notice. Other than yourself, your intellectual property or IP is one of the single greatest assets to your business. And there's probably two key areas of IP that you like to come across. Firstly, there's trademarks, so think of the McDonald's arches or the Nike swoosh. And there's also copyright, so that's pretty much anything in writing or film or music. And there's a whole host of other IP rights, such as patents, which tend to apply to technical products. There's design rights, domain names, and a whole host of other rights that could arise. The key thing really at your stage is to identify what IP rights you have, and then take steps to protect them. Now for copyright, protection arises automatically just by virtue of it being created. Nice and easy. For trademarks, the position isn't quite so clear. Whilst you can gain some protection through using a trademark in the course of trading, the more advisable thing to do is to register your key trademarks with the Intellectual Property Office. And it's a fairly straightforward process on the Intellectual Property Office website. And the key things to be thinking about here really are your key brand and product names. Now on data protection, there's no one-size-fits-all approach to this, and it's a vast area. But the key things to think about are to make sure that you always have a lawful basis to process and store somebody's data, and wherever possible, to minimise that collection and processing of data. The Information Commissioner's Office, or ICO, has really useful guidance on its website that can help you pull together a data protection policy and help provide really useful hands-on guidance for how you can comply with the data protection obligations. If I had one piece of advice for a founder at the start of their business journey, it would be to focus only on the legal steps that preserve or create value in your business, or that help to prepare the business for an investment or an exit.